Hello, good night. This is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. And I do have two very important updates for you tonight to talk about. And it's important for you to know this information. So go ahead and put those open up your ears and get ready to absorb what I'm going to tell you. But we're also going to focus on solutions here. Um, Now, we have two decisions from immigration courts and the Supreme Court today that are not that great. Actually, very bad. So the first one, we have the Supreme Court decision. The Supreme Court, so in California, they had sued, is trying to prevent ICE from basically putting limits on ICE and how they conducted the raids. Who did they target? How did they target? There was um, a lot of targeting of immigrants based on just the way they look. And, traditionally, that is not constitutional. So they went to the Supreme Court to first, it went to the lower court. The lower court did put a ban on ICE, just stopping people based on the way they look, their skin color, or based on them speaking language, or based on whether they looked undocumented. They put a ban on that and said they could not do that in California. Well, this went all the way to the Supreme Court, and the Supreme Court has now said that, yeah, they're going to lift that ban. The lower court can still decide, make a final decision. But in the meantime, ICE can move forward with targeting people based on the way they look and the language that they speak. So, in other words, racial profiling. The populations that are going to be affected are going to be the Black and Latino communities that are going to be targeted here. And they are saying it's okay to round up people. And if you round up a couple citizens and green card holders, it's justified. So that's alarming here, guys, is that we are all not safe if we're in the wrong place at the wrong time. Even as US citizens, green card holders, legal visa holders, we can be detained. And Lord knows what happens in detention. Actually, unfortunately, I am aware of some of the conditions, the terrible conditions in detention. So it's like going into a black hole once you're there. And guarantee, if they're detaining a U.S. citizen, a legal permanent resident, a visa holder, they're going to be there for a couple days, just sorting out their status. So it is alarming that they're allowing this. And traditionally, this was not allowed. It was seen as unconstitutional. But right now, the court is indicating that they don't see anything wrong with this when it comes to immigration. So the other one is in regards to immigrants who entered without inspection. So anybody who, if you came by boat, you never went through the inspection, as in an officer, a U.S. officer inspected your papers and let you in, or if you came across the border, they're saying if you are detained. Now, this is a BIA decision that just came down on Friday. And it's bad news because it's saying that any undocumented immigrants who have come into the country without inspection will be detained mandatorily, no bond. So where many individuals, so previously it was limited to new arrivals. So individuals who just came and they were stopped at the border, apprehended, or close to the border, they were apprehended within, say, 2 weeks of arriving, they would not be eligible for bond. However, now they've expanded this to all immigrants who entered undocumented, and it does not matter how long you've been there. Before, it was those who have been in the country for less than 2 years. Now, they don't care. The BIA has now said they agree with the policy that the Trump administration has issued, saying that all undocumented immigrants who enter the country without permission will now have to fight their case while being detained. So, you know, this is also extremely bad news, because it means that people are going to be detained without an end in sight. Now, usually detained cases do go forward faster than non-detained cases. So that means we expect that the cases would be fast tracked. However, with now they are looking to expand detention capacity to over 100,000. So if they do that, it means that individuals, there's going to be a backlog, right? And that means people are going to stay locked up, and they're either, because of that, the poor conditions that they're going to be detained under, even if they had options, they would opt to leave because they can't take the conditions anymore. And if they do try to stick it out, like going back to their home country is not an option, it means that individuals are going to be staying in those conditions for a long time as we see more and more people getting locked up. They have $45 billion now towards expanding detention. And that means expanding detention to over 100,000 people. So that means that even in the case of bond, lawyers, unless this goes to the federal court and the federal court determines that reverses or goes against that BIA decision, that is really the only hope at this point, because a BIA decision does mean that the judges, the lawyers have to abide by what that BIA decision does say. In addition to that, we also have the Attorney General passing down the decisions herself now, saying that people who have faced domestic violence in their countries, who are seeking asylum here, or they are fleeing from gang violence, those now will be looked at narrowly, very narrowly, and that means that many of those cases will be denied if it doesn't meet the very specific criteria involved. So things are getting harder, in regard, and specifically in regards to enforcement. So this is where ICE comes in. This is where the policies are getting harder. Also in discretionary type situations like TPS and parole, we saw just in the past few days that they went ahead and terminated TPS for Venezuelans. A court has now blocked the termination of the TPS, but once it expires, there is really nothing that the court would be able to do because it is discretionary. Now, this is where I want to stress. Now, yes, bond is not no longer an option for some immigrants who enter the country without permission. It does not include people who came in with a visa and overstayed. So keep that in mind, unless you're a new arrival. So if you're a new arrival, that you overstayed, you were apprehended close to the border you entered in the last 2 years, that could also apply to you as well. However, if you have been here for over 2 years and you enter the country with a visa, the bond is still a possibility at this point. And then also, whether you are entitled to bond or not, you need to know that you have a chance still. Court, even though it is stressful, it is very stressful, especially when you're in that situation where you're detained. But there, if you know that you really have no choice but to stick it out because you cannot go back to the country, your home country, or you know that you qualify for a legal option here, you can still fight it while being detained. But it's very important to make sure you have a relationship with an attorney so that they beforehand. And why I say that is because we are involved in these cases now, and what we are seeing is the cases where we knew our clients before, we could jump into action very quickly because we had everything signed from our clients, versus new clients that we're just getting to know them after detention. We're talking to their family. The family is scrambling to get what we need. We are now scrambling to get what we need to get in touch with the client very quickly. And usually, some time can pass before we can actually gain access to our client who is detained. So I can see the differences already. And so what I say is, before anything happens, make sure you have a plan, make sure you have an attorney's number. Right now, we are also making sure that we are ready for emergency situations. We are here to help clients get through their removal process to be able to defend clients and provide them the options to even fight their the deportation. It's possible. It's possible. And that really is the last effort, the last chance to be able to get the relief. So, two very terrible decisions, but what I can say is the legal options that we help our clients with are still there. And we still see that there are options to continue to fight in that, in even if they're detained, whether they're not, we can still fight for them. And that is where we focus on. We focus on what we can control, the solutions. The types of solutions we work with are statutory law. So Congress can't change it, the president can't change it. Yes, the way they look at those cases can be different, but what we do is we rise to the challenge, right? If they change the way that they look at it, we know legally, based on what's written in the law, our clients qualify. So the only thing left is, okay, we know our client qualified. So what do we need to show? Let's show it, right? So this is where I say, get in touch with us. Let's look at those options. And also just make sure that you're looking at potential options before anything like this happens where detention occurs. But if it does, make sure before it does, you have an emergency plan laid out. Make sure your family has access to your documents. Make sure that you give your family members your A number. The A number is very important. That basically helps the clients locate you quickly, because they're flying people all over the country. So somebody can be in Florida 1 minute and Texas the next. They really are, and we've had multiple clients that have been moved without notice across the country or across state lines. So they are doing that. Just because you get detained in Georgia, it doesn't mean you're going to stay in Georgia. And they can do that very quickly. So the way that we can locate is by the A number. So if you know your A number, if you don't have an A number, they may assign it, or you may not know it. But if you know it, have your A number ready. Make sure you have all your documents lined up. Make sure you have a history, your immigration history, so that your family can relate, and then the attorney can be able to understand what your immigration history is and use that to be able to defend you. Now, before anything like this happens, there are legal options like VAWA. So if you have been mistreated by a U.S. citizen or legal permanent resident spouse, parent, or adult citizen child, that's a way forward to get protection and get your work permit while being here. They are still processing these. We are still getting approvals for these. The T visa, if you face abuses in your work, we want to talk to you to find out what are those abuses. Oftentimes, immigrants put up with abuses that are egregious, but to immigrants, they don't really know that they have rights. And so they are a victim in this situation and they don't even know it. Because of this, though, because of situations like that, we've been able to get our clients help in order to be able to um, get their papers, get their legal papers and protection here in cases like those. U visa. If in the past, no matter how long ago, if you reported a crime to police, we want to talk to you, figure out what happened in those cases. You may be able to qualify for deferred action while a U visa is being processed. Yes, the U visa is 7 to 10 years, but you do get deferred action protection while it's being processed. Asylum is still there, guys, and we are still getting work permits. We're still getting the ability to, we're still getting approvals for asylum. So, in the case of asylum, if you've been here, you're about to lose parole, you're about to lose TPS, or you have come within the last year, we want to talk to you about why you fear going back to your country. Because you may very well qualify for asylum. It is still being processed. So these are some examples. Now, here's another one that you need to know about. If you're here and you are without your papers, there is something called Section 245I. It's a section of the law from the Immigration and Nationality Act. And it says if you're here without your papers, whether you cross the border without permission or you overstayed your visa and you had a petition that was filed for you on or before April 30th, 2001, you know the petition, or you could be a derivative on the petition, or it could have been a labor certification that was filed for you. If that's the case, and that petition was filed on or before April 30th, 2001, then you may still qualify to apply for adjustment of status that gives you temporary protection while they make a determination on your green card. But keep in mind, you do still have to qualify through an employer or through a family member for adjustment of status, along with the 245I exception. So this is what I want you to know. If you had any petition filed for you on or before April 30th, 2001, a petition or labor certification, it's time to give us a call, talk to us about that situation so we can determine whether that can also give you temporary protection while being here. All right, so those are some options available. I say give us a call ASAP. We are 24/7. If you call right now, you'll be able to talk to a team member here because we're running around the clock to be able to help as many people as possible. And right now, I see where immigration enforcement is becoming brutally tough. And the options that we work with are still there. And keep in mind, you still have the ability to defend yourself in immigration court, but that's stressful, right? So while we do help clients to get through immigration court, we want to avoid that by proactively applying for relief that can help put you at an advantage, give you protection from deportation, but even if you're detained, it may be a way to be able to still get bond, or eventually get your case terminated because you qualify for this. All right, so I am going to leave it to you to be able to reach out, take action. I'm solution oriented, and I've presented to you, yes, very tough situations, but it's our job here to get through those tough situations and get results for our clients. And so I've presented to you a number of ways, number of possibilities that we look at for our clients to be able to allow them to still get legal status here, protection, security for themselves and their families. So let's talk. That's going to be important. Thanks for the follows. Thanks for the love. Keep hitting the screen on TikTok. Keep sharing, subscribing, liking on Facebook, YouTube, and Instagram. That is how other people see this information that can empower them through this immigration journey. And we're solution oriented. We walk on faith. We do solid legal work, and we're solution oriented. We look at the solutions here. All right, so let me answer some questions. I see a ton of questions on TikTok, but go ahead, put your questions in. I see on Instagram as well, and I definitely see on YouTube and Facebook. I'm going to get to these, but go ahead, and I'm going to start with TikTok. And in the meantime, put your questions in. If you have a 212E visa, what are you qualified for? So I believe the 212E is the J1. So 212E visa is the J1 visa, and it just means you're qualified for the J1 visa if you've gotten married to a U.S. citizen, if you've had an employer who wants to sponsor you. Maybe that opens up the door to something else. If you are here and you're being mistreated in that situation, that J1 situation, you're not being paid, you're being paid late, you're being forced to do work you didn't agree to do, then we want to talk to you about the possibility of other options that could be available. But when we talk about the J1, we also are concerned about the 2-year foreign residency requirement. So you would also need to get that forgiven. But keep in mind with the T visa, it may not be so much of a problem. But if you qualify for other forms of relief, that's where you'd need to get a waiver for that, which we do that as well. A friend of mine has an ICE check. Should he go? So legally, he's obligated to go. If he does not go, he's going to become wanted, and they're going to apprehend him. So I can't advise. It's always their decision. It's always a person's decision on whether to go or not. But usually, if you have an ICE check-in, it means that there really isn't any. There really isn't any other option. And also keep in mind, ICE check-in too could mean, do they have withholding of removal? Because withholding of removal is a type of protection in itself. So if they have withholding of removal, I would, that would mean that a court has already granted that person, that immigrant protection, and they're just doing their check-ins. So it depends on what they had approved. Did they have anything granted to them? What are their circumstances? But it really is their decision. But, a check-in is usually required. If you don't do the check-in, it means no, you're definitely going to be wanted by ICE. Should Hispanic citizens start carrying passports and legal documents? Unfortunately, you should be carrying proof of your citizenship. Now, in some cases, your driver's license may indicate your status. So just having your driver's license, having your real ID could provide proof of your citizenship and or your current status. For green card holders, you must have your green card with you. You must take your green card with you, or the stamp in your passport or your extension letter and your green card with you. at all times. You don't want to be caught without that, because they are more inclined to detain you if you don't have your papers. And of course, you can't say you're not a citizen. So unfortunately, in these times, make sure you do have some form of valid government issued ID. The real ID, driver's license, could show citizenship. But if you don't have that, then make sure you have another form of ID. And if you don't have, say, you don't want to take your passport, maybe take a copy of your passport, and then make sure you have your passport and important documents in an important location or a secure location. So if something happens, that can be accessed quickly by family members to provide, proof of citizenship. When can I expect card to arrive after a case says card being produced? So it sounds like you got your card produced. Congratulations. I usually see it within a week or two. When can I expect? Let's see. My friend has DACA and deferred action from a pending U visa. Does that protect her? Yes. It provides a lot more protection than not having anything at all. Absolutely. That's the best case scenario right now. Is it smart to file a new I-130 after the first one has been denied? I would say talk to us. Talk to us about your situation so we can determine your risk. Right now, filing petitions, especially if you're filing petitions without an affidavit of support, I mean, an adjustment of status. So filing an I-130 petition without an adjustment of status, and you're here in the US and you've overstayed, it's going to put you at a high risk. So we would want to talk to you about what's going on, what are your circumstances, to determine if that's good for you. T visa, what if the victim can remember the abuser name, can't remember the abuser's name? So it really depends. I would say that I've had situations where it happened so long ago that my client couldn't remember some of those identifying details. But we focused on the details that our client could remember, and we got it approved. So it's still possible. Of course, you shouldn't purposely withhold the name of the person, because sometimes we can tell when the person is doing that, or sometimes immigration can question the credibility. So if you have that information, know that it's confidential. It's safe to disclose that information in a T visa application. They don't contact that person or go after them necessarily. They don't. It's all confidential, and it depends. I shouldn't say they don't go after them, but it's on a case by case basis. It really depends too on what our client wants. If our client wants justice, in some cases that's the case, then they may pursue an investigation. But if the client doesn't want that, then it doesn't have to go that way. So it really is on a case by case basis. But it's confidential, so you should not be intentionally withholding any information, because that can affect you. But if you absolutely can't remember something, that can be acceptable, and we just have to focus on the details you do remember. Can arrest record deny I-485, not the conviction? So here's the thing. Unfortunately, I can no longer say. I say whenever you have an arrest, you need to evaluate that. But there's also additional things we need to keep in mind. Like, for example, anti-Americanism. It's very vague what that is all about, but anti-Americanism could look at your record and look at the arrest and use it against you, maybe even claiming that it is evidence of anti-Americanism. So we would have to really look at the arrest record to see, was it dismissed? what happened, to determine how it's going to affect your I-45. And I suggest you get to that ASAP. Been waiting for my 10-year green card, but today I got a message saying it's recalled. What can I do? Oh, I'm so sorry. That is not good. Now, keep in mind that in the new policy manual, they have stated that if a relative or a petitioner withdraws their petition, they can still terminate or withdraw their approval of basically your petition, and as a result of the petition, your green card, based on that withdrawal. And they have stated that even if they approve it, even if they approve the green card initially, but the petitioner wrote and withdrew, they can then withdraw their approval. So I'm not sure what happened here. I don't want to jump to any conclusions, but recalled sounds like it is they have pulled it back. And I don't know why. And this is where it's important to get legal assistance as soon as possible. But here's from a strategic point of view, here's one thing I want to say. If you don't trust your family member, your spouse to file for you, you're noticing they're blackmailing you, they're threatening you, they're mistreating you, and forcing you to live under those conditions with them because they use the filing of the petition against you. You should really consider taking it into your own control and filing for VAWA, because that means oftentimes I've seen it. They go ahead and sneakily go withdraw the petition, and that could cause a denial or withholding of the green card. So and I've seen that happen. Them do it in secret, right? And then you're surprised by it. So make sure that you're also looking out for your own interests to make sure that you can take control of your own process if your relative is mistreating you. Can I petition for my 10-year-old son? If you're a green card holder or a US citizen, you can petition for your 10-year-old son, even if they're overseas. Absolutely. Thank you for sharing the live. I appreciate it. Thanks for the follows. I appreciate it. And thanks for the love. I appreciate it. And this means a lot more people are seeing these. If we are in the process, can my husband still get deported? So this is a big question. And if you file it properly, everything is done correctly in your process, they will not be. So they're protected by adjustment of status process. I don't know if you're going through that process, but they are usually protected by a properly filed adjustment of status application. So this is where I say now is not the time to try to do it yourself or try to see if it works out. This is not like going to the bank and filling out forms, or going to a government office and filling out forms to see if you qualify, right? This doing it incorrectly, missing information, missing documents, applying for things you may not qualify, has real life consequences now on people's lives. So even if you have marriage base, you need to make sure you're doing this correctly. TPS Nepal, what should we do? Look at asylum, look at other options. We would love to talk to you to evaluate other options. Do USCIS questions petitioner and beneficiary at their marriage-based interview? Yes. Yep. So the interview is something we're going to be seeing very often now, and they are going to be asking. So in the interview, they'll have both of you in the room, and in some cases, they may separate the spouses and then start to ask questions to see, they'll ask the same question. So they'll say, what's your favorite food? Maybe to the immigrant spouse. And then if say she says jerk chicken, and then they will go to the citizen spouse and say, okay, what's your spouse's favorite food? And they'll expect them to say jerk chicken. If they say anything else, then they definitely take those questions seriously. Inconsistencies. So I have seen notices of intent to deny, which we have won twice when we got these notices of intent to deny. These were people who filed the cases on their own, came to us and showed us a notice of intent to deny. It was usually based on the interview. So the interview went south, and everything looked good in terms of them living together, documents, but then they go into the interview and nerves sometimes get the best of them, and their answers may not be pristine. And because of that, they look at those answers and then say, okay, we don't believe you have a bona fide marriage based on the answers in your interview. So we're giving you a chance here to solve all of these. And they'll give a long list of the inconsistencies that they found in the interviews, and we have won those. However, it's stressful, and it really, the notice of intent to deny is a last chance. It's a last chance to get it right. And unfortunately, under the new USCIS policy manual, they're saying the officer doesn't even have to give you a chance. The officer can deny without giving chances. So it's very important to make sure that you go ahead and get all the assistance, prepare sufficiently for that interview. Can I file for my daughter back from African under Trump administration, and how fast is the process? So it depends on the age of your daughter. Sometimes it can vary anywhere from, I'd say, year and a half, 2 years, to over 10 years, depending on the category. So give us a call, talk to us. After I received a message that my 10-year green card was recalled, reason was it was error printed. Okay. So if it sounds like there may have been an error. I don't know your case. I'm not your attorney. It's simple. You can call them to determine what the error was. But if they're saying it's an error, maybe they got your name wrong, they got your date of birth wrong. It might be something like that. If you have overstayed and yet married to a citizen, can you adjust status? Absolutely. This is a major misconception that's now, I can bet, making a lot of people not apply for things that they qualify for. If you are the spouse of a US citizen and you overstayed, by law, you can still apply for adjustment of status. And that adjustment of status process gives you the protection to be here while you wait for the green card decision. But if you do nothing and you don't apply for this, you are fair game for ICE to come pick you up off the street and detain you. And at that point now, you can't apply for adjustment of status anymore at USCIS. You may be applying for it before an immigration judge and be detained while you're going before the judge. So guys, if you qualify for something legally, go for it. Go for it, because at this point, you're just a sitting duck if you do not go for the legal relief and benefits that you qualify for. The law says you qualify for it, go for it, right? The policy manual does not say it does say if you file a petition without an adjustment of status and you're overstayed, yes. But with once you file that adjustment of status, you are in a safe zone, but it must be filed correctly and you must qualify for it. Um, can my 18-year-old go for a visa interview without a guardian? So it depends. So 18, yes, they can go without a guardian. It's even though they're considered children are under 21 in most cases for immigration, 18, they can go on their own. I don't know your situation. I don't know, what kind of visa it is, but in some cases they may be able to bring somebody with them if a petitioner is involved. Do they start VAWA interviews yet? Yes, they're doing VAWA interviews, and they're doing that to make sure that people aren't committing fraud, because there were a number of fraudulent people committing fraud, telling people, "Oh, we're gonna apply for you to get your work permit," and it turns out they were applying for VAWA, and the person never qualified for VAWA, so it's a fraudulent application. So now they are doing interviews to make sure that these people applying for VAWA know what they're applying for and that it is true. If you have overstayed, so let me see. What do you think one should expect for I-485 interview after VAWA has been approved? So after VAWA has been approved, they're usually going to focus on your admissibility. So do you have anything in your background that makes you inadmissible, like a criminal record? So they're going to go through the questions on the I-485, know your I-485, know your VAWA, just in case, petition by heart. Make sure you remember and you understand, and you can even update your employment history, your address history on the I-485. If you've had any arrests or issues, you want to make sure that you can address those legally. And the way it says address depends on how what happened, what were the offenses. What do you think about notarios? Um, so they're not attorneys. Some of them pose as attorneys here, and because of that, they got a lot of people in trouble. So I would say this though, unless you are like a certified immigration specialist, and certified, I believe immigration certifies these people. So, for example, it's going to be immigration that gives them the ability to be immigration specialists. You should not be going to those, because here's the common observation is they will do the paperwork for you, and reassure you this is going to be great, you qualify, blah blah blah. It goes in, and then if immigration has any questions for you, they're nowhere to be found. Or if you're still in touch with them, now they're going to break it to you that they're not an attorney, they can't handle it. Have an attorney at this time. Things are too complicated to get it wrong. Do you think it's necessary to get a lawyer to file an N-400? Yes, I'm going to be straight up now. You need a lawyer in these cases, because these cases have become increasingly complicated. Now, citizenship is complicated. Citizenship, they are now requesting, the way I would say citizenship now is like applying for the best job of your life. That's how it is. You're going to have to show why do you deserve citizenship. They're looking at anti-Americanism. They're screening for anti-Americanism. They're also screening for good moral character. But good moral character does not just mean, oh, you didn't get any arrests anymore. It means, okay, well, what have you done to deserve citizenship? And I would say one of the things that you have to they're going to look at a number of factors to look at what have you done that's good, that makes you deserve it. So it's about framing that application from the start, and that's one thing that we're good at, right? Is just making sure that that we present the information immigration needs to make a decision. All right. Okay, where are you located? We're in Delray Beach, Florida. We represent clients in all 50 states and the globe. Thanks for sharing the live. Is it true I-130 appointments are getting approved in months with no interviews? So keep in mind, no. So I-130, no. I-130s, one thing you need to know, and I think this is where people get confused and get into trouble, is I-130 is the approval of the I-130 is not what gets you the green card. So even if an I-130 was approved within months, it's not leading to a green card. If you don't have the right documents, like the adjustment of status filed with the I-130, if you're here in the US, that's where you could get into trouble, because here's how it could go, ironically, is you will get a message saying, or a notice saying, congratulations, your I-130 has been approved. Oh, and by the way, you're here in the US, you've overstayed. So here's a notice to appear in immigration court at the same time, right? Because you didn't have an adjustment of status application that helped to protect you from going to removal proceedings. So it's important to have the right documents along with the I-130. So yes, I-130s may be approved in short order without an interview if you're outside of the United States, for example. But even if you're here and it's approved without an interview, they're still sending a notice to appear if you don't have an adjustment of status application. Is it possible to file for an H-14 visa for your child is it an H-4 for your child if you're in the US? I believe if they qualify as a derivative of the visa, then yeah. Do you think it's necessary to get a lawyer to answer that? Good night. Applied for the 245I for my parents. They got their work permits. Great. So this is an example of using section 245I. So I just mentioned that if you were petitioned for on or before April 30th, 2001, you or your parents were petitioned for, then you need to see if this could allow you to stay here, even if you overstayed your visa and even if you entered the country without permission. How long to wait if my I-485 said your case is taking longer than expected? It depends, it ranges. So adjustments of statuses can range just depending on case type. If you have a clean record, not even a traffic ticket, 40 years in the US, help you get your U visa faster? No, unfortunately, it doesn't. What would get it faster is, there's nothing that can get it faster. If you are facing any conditions, any urgent situations, you can ask for an expedite. Thank you for the gifts. Thank you for the love. I appreciate it. How long to wait if my I-485 said so I answered that. What is the cost to schedule an appointment with you? So here at SC Law Office, we have multiple attorneys. It's 150. You can go to the link in the profile and complete our evaluation form, and that's going to lead you to book the appointment, or you can give us a call right now and schedule. Can I appeal a denied I-130 or just reapply? So It depends. We'd have to look to see. Sometimes it just makes more sense to reapply, but we want to see what the issue is first to be able to determine how to move forward. Do you do H4 visas? So we wouldn't just do an H4 visa alone. We'd have to, it would have to be a part of the entire case. If your I-485 has been approved, how long does it take for the green card to come? I would say 1 to 2 weeks, maybe even up to 4 weeks. Is it okay to travel domestically via plane with my work permit and real ID and social security? It should be. Domestically, it should be. Um, does filing for an I-601A would guard against removal? Great question. Right now, I would say the I-601, no, there is case law that says that it should protect you. So I have seen case law that says that the whole reason, purpose of the I-601A is to allow someone to get forgiveness first before they travel out of the country. However, we have yet to see how that is affected. If anybody has been affected with the I-601 with A, have they been referred to removal? We have yet to see that. 2 months now, I got my citizenship and just find that they start with my last name on the certificate. Well, if that's a mistake, then you'd have to get it corrected. Can an immigration lawyer contact and speak on a client behalf about their case? Yes, yes. If authorized, the attorney can do that. All right. So I am moving on to Instagram and then I'm going to YouTube and Facebook. All right. So I'm excited to see questions here on Instagram. I didn't send anything after my divorce. I have I-751 pending. My ex-husband who informed the USCIS about divorce, they know I'm divorced or I have to do something. Even I call them and they said I have to wait. So please do not call USCIS and ask them for legal advice. You can ask them general information, but please do not depend on them to give you legal advice. They told you you had to wait. And in the case where you waited and then you went to your interview, that could turn ugly very quickly. You could get issued a notice to appear right away. So what I would say, and we have dealt with cases like this, we have won those cases. You need a waiver. Get in touch with us ASAP to talk about that waiver and get moving. Because if you do not inform them about the divorce, then you could end up in a lot more problems. So they could straight up right now, based on their policy manual changes, they could just send you a denial, right? So what are you waiting on? What did the officer say you should wait on? And not even an officer, an information person, like an information officer told you to wait. What are you waiting for? The best thing you can do is to take these procedural steps to get it right. If you do not, they know of the divorce. When the file hits the officer's desk, they see you're divorced, but they don't see a waiver. You didn't check on that form that you're applying for a waiver. They are going to deny, right? And if they deny it, you're going to immigration court and now you're defending. You get a second chance to argue it in front of a judge. But who wants that kind of stress? You want to avoid that stress to begin with. Is marriage-based the only option for you if you don't have a family member filing for you? No, we look at other options for our clients, but it really depends on your circumstances. So we have to talk to you more to figure out what do you qualify for? What have you been through here that you may have other options available? Can a U.S. citizen file for a cousin on a visitor's visa? No, absolutely not. Good night. Hi there in North Dakota. And just I saw Josiah again. I just answered your question. Loving the work you do. Thank you, Roderick. It's always nice to see you. Um, Dear attorney, I have a pending I-360 for almost little less than 2 years. Wanted to change my attorney. So one thing I want to make clear here, because a lot of people get impatient and you think that it's the attorney that's making your case longer. Um, Keep in mind that it's not the attorney; it's the immigration that that's just the way it is, right? So if you want to open up the communication with your attorney, it's always your right to change attorneys. But if you're doing it because you think that somehow another attorney is going to make your case go faster, think again. Most of what you should be concerned about is what was filed. Do they have all the sufficient information to make a favorable decision? And yes, it's a waiting game. It turns out to be worth it in the end, but yes, it is a waiting game. And no, the attorney cannot make it go faster once you're in the processing time of the USCIS. Having a work permit based on asylum, is that safe, or if detained will be released? So have your work permit with you everywhere you go. And once you have that work permit with you, it is there to say you have permission to be here. Does it 100% guarantee you won't be detained? I would say that's not a guarantee for any of us. I could be walking down the street with these policies in place. I could be walking down the street and I get detained with all I have, right? I could whip out my driver's license and it still may not make a difference. So it's the same here. I would say you have a work permit. Um, it is likely to protect you, but none of us have 100% guarantee at this point. What type of attorney should U.S. citizens get? So I know it's really nerve wracking hearing that even U.S. citizens, not naturalized U.S. citizens, or U.S. citizens that are like, for example, I was born in New York, right? So I am a born. I'm not naturalized. I was born here in the United States, but I have a Jamaican accent and I'm Black. So, because of that, I could possibly be targeted for immigration enforcement being in a certain place at a certain time. Um, so, yeah, I get it. US citizens are on edge. It would be an immigration attorney, but I would say with US citizens, you would really have to get that when you are if you are in a situation. There's really no need for an immigration attorney if you're already a US citizen, but you are not facing anything, like your US citizenship is not in danger. Um, but it would be an immigration attorney. What about if you get detained and have a T visa case in effect? So then the T visa, we have brought this before the court, and then the court will consider it to grant bond, or even in some cases, if once a T visa is decided and it's approved, then your case goes away. It's terminated, closed, you get to move on. So the T visa, having a pending T visa, can provide you a strong, the ability to project a strong defense as to why you should be given bond, or maybe why your case should be terminated. And it also gives the ability to expedite your T visa case, so that if once your T visa is expedited and approved, they can quickly take it to the court, and then the court can see, oh, you have a T visa approved, and close your case. So I say applying for anything you qualify for. If you qualify for the T visa, apply for it. Anything you qualify for, apply for it now. Because being a sitting duck is not doing anything for you. What I'm seeing is people who have nothing pending and they're detained. it's like going into a black hole, right? And it's very hard to communicate if you don't establish a connection to begin with. It's very hard to communicate. So for example, having an attorney who's working on your T visa, you being detained can help that attorney to jump into action, to be able to get you bond or to get you released or get your case closed. I have filed VAWA and in Oregon, and I am currently in Illinois. What if USCIS schedule me for an interview and my attorney don't want to fly from Oregon? Can I find one just for the sake of interviews? So you may, however, it may be hard to do that because the attorney may not know how, with me, I usually provide the option to attend my client's interview. So I give them that option, or sometimes I'll even tell them, it's definitely gonna be required in this case. Um, and in some cases, attorneys can work together. So your attorney in Oregon, I don't know your attorney or how they function, but sometimes your attorney in Oregon can touch base with an attorney that they know in your state, and they can have somebody fit in for them. I don't know if that is a possibility. But yes, you can always find another attorney who can then attend, but it just depends on the attorneys. Like, for example, for me, I don't usually just pick up and go to an interview for a case I didn't file. I reserve that option for my clients that who I filed their case from the beginning. All right, now I'm on Facebook, YouTube. So go ahead, put your questions in the comments. Good evening. I have a C-14 through my Visa U, and I don't have a single criminal case. I have to attend the graduation of my son who serves in the armed forces. I may be going by plane. So if you have the C-14, which I think is your work permit, you should be fine. You have a current valid work permit, you should be fine. But if there's anything you're concerned about, talk to your attorney. How long are T visa cases? I think that's what that means. So they're up to 2 years, but in between you get a bona fide determination. You get considered for a bona fide determination letter that gives you temporary protection from deportation. You would then get your work permit while you wait. And then after that, should you get the approval, you get another 4-year work permit and then a path to the green card during that time. So, you have benefits that are rolled out throughout the almost 2-year process. Hi there, Karen. Nice to see you. If a person has a T visa they just sent in, would there be any protection? So I would say carry your receipt notice. And it's receipt notices are taking about 3 to 4 months now. Hopefully that changes. Sometimes we see this happening. Of course, a lot of new stuff is taking place behind the scenes. So it's taking 3 to 4 months. Take your receipt notice with you. Make sure you can show that you have a pending process with you. Now, and it really depends strategically on what you're going through. This is my number one go-to is remain silent. Don't talk about your status or anything. So that's one, right? Is to know your right to remain silent and just make sure that you are exercising that right. However, if you're in the situation where you need to show that you should not be detained, if you ask, "Am I being detained? Am I free to go?" and now they're telling you that you are going to be detained, then one thing I tell my clients, which may not apply to you, so this is where having a lawyer is very important, because it's all about strategy. But in regards to my clients, is have your receipt notice and your have your receipt notice ready in case they're about to detain you. And that could be your opportunity to say, I have a pending process here, but don't over disclose, just enough. Have the ID, have the receipt notice, in order for the officer to see, okay, they have a pending process and this is their ID. But if they go to detain, or they start asking more questions, that's where you say, I reserve the right to remain silent. So strategically, it all depends on the situation you're in. What's the ITIN fee? So give us a call and talk to us about the ITIN fee, and then we can tell you on the phone. And it's a free evaluation as well, but we need to make sure you're qualified. So give us a call. Will ICE still arrest you if you have a work permit? Work permit. So guys, what I want you to understand is, when you get approved for a benefit like a work permit, it's actually saying you have permission to be here and to work here. What is bad is when you're sitting there with nothing in hand. When you have a work permit, that's good. Now, does it 100% guarantee that they won't arrest you? It doesn't. No, it doesn't guarantee that you won't be arrested by ICE. However, it significantly decreases your risk of being detained. But even if you are detained and you have that work permit, you present the work permit, you may be detained for an hour or a few hours and then released because you have the work permit. So this is where I say, no, it's not the time to hide. If you qualify for something, you need to go for it, because that is your best bet. I want you to be able to see two situations here. There's the situation of immigration enforcement, where, yes, we're seeing now racial profiling, and we're seeing in some cases some immigrants are being denied bond. Some still can get bond, right? That is immigration enforcement. And once you're in it, then you have to go ahead and look for a defense against deportation. But there's also the other side, that in statutory law states that if you qualify for this, they're supposed to process this for you. And if approved, you're protected. Some of them offer mechanisms to protect you from removal or detention while you're going through the process, like adjustment of status. If you can qualify for any of those before you get to the immigration enforcement side, it would reduce the stress. It would reduce the possibility that you're going to be deported, because you're applying for something that you're qualified for. And this is where I say, that's what we do. While we can never guarantee results on our end, what we do is we don't just tell everybody to apply. We choose cases that do qualify based on our experience, based on our approval history, based on the law, the written law. We look at, we do an evaluation, we do a strategy session, we talk about the case with the client, and then we say, based on everything, it looks like you qualify, let's go for it, right? And that in itself is the first step to getting protection. Okay, so so you can't just sit there, hide, and then pray that if you get arrested, something is going to happen. You need to be proactive. Let's see. Can you travel with your advance parole if there's an emergency? I would say this is it's very risky, and it is your decision. But traveling on advance parole is not an entitlement. It does give you the ability to travel. That's what it's there for. But coming back in, any little thing happens and they decide not to let you back into the country, um, you know, then you're stuck, right? So you have to bear that in mind and determine for yourself, is it worth the risk? Can I travel by plane within the US having the C-14 through the U visa? I need to be going to my son's army. So work permits usually allow you to travel domestically. What do you say if you want to change my attorney now while my I-360 is pending for 2 years? So I had already said, it's not if your I-360 is pending for 2 years, it's not the attorney. It is the processing times. I would just make sure that everything is, solid in your VAWA petition. If you got a T visa pending, how can you get your partner of many years into the country because she was denied a tourist visa? So usually you would have to be married, so your spouse can get the T visa along with you. We just had our client whose spouse and child was able to get the visa and join our client here on the T visa as well, but that's only for married couples. How long does it take to get the EAD card after approval? I'd say 2 to 4 weeks. I'd say a week. I'd say 1 to 2 weeks. If there's a real backlog, maybe 4 weeks, but I've seen 1 to 2 weeks. Hi there, Domain. What if I had an attorney when I was filing my T visa application, but due to financial challenges, my attorney terminated my contract? Will it be a problem? It depends. I mean, that's more of a contract issue with the attorney. So it's not an immigration issue per se. But here's what I would say in a situation like that. The if you don't have your attorney and you get a request for evidence for T's can be intense, and it can have a lot of requests for legal requirements that you may not understand. And your case may be totally winnable, but without the attorney on the file to be able to correspond with immigration, then you could meet serious challenges. If you can't respond sufficiently to the T visa request for evidence, that could be a denial. Also, keep in mind, T visa is very confidential. And so the attorney's address, you'd have to make sure you contact them in writing to be able, we contact them via email, but just it's only an email for attorneys, but you'd have to contact them in writing to have the address changed to your address. And the question is your address a safe address? So you just have to think about things like that. So your T visa may be compromised if your attorney is no longer on your file. If you got a work permit change from 2 years to 5 years, what does that mean? So they're right now they're issuing 5-year work permits. So that was what happened. Did you get your renewal? Did you renew it? And it went from 2 years and now you have a 5-year. That's normal. How soon? So work permits right now. So T visa work permits are 4 years. Marriage-based work permits are 5 years right now. How soon after you apply for a marriage-based green card do you get the work permit? I'd say 3 to 6 months. I'd say 2 to 6 months. My shortest was 14 days. Next shortest was 2 months, but I would say the average is 3 to 6 months. Asking for a friend, can you switch from asylum to family-based? You not necessarily switch, but you can apply for them both at the same time. You just have to make sure, talk to an attorney, make sure your asylum is what happened with the asylum. Just make sure you're doing everything properly. Good morning, by the way. It's 12:15. Thanks so much for spending this time with me. Good evening. If someone comes on a J1 and tries to switch to an F1, got denied, and later got an NTA, can they adjust status if they marry a citizen? It's maybe possible, but keep in mind that once you get married while you're in removal proceedings, the standard gets much higher. Now, instead of just showing by preponderance of the evidence that your marriage is real, now you have to show by clear and convincing evidence. That's like almost to a certainty that your marriage is real. So it's possible. You have to do it before the judge as well. So you do file the I-130 that goes before the USCIS, and the USCIS applies that high standard. And then if it's approved at the USCIS, the judge can approve the adjustment of status in court. So rest assured, it will definitely be challenging if you are married after the NTA was issued. How long you have to wait for a green card when your parent is a United States citizen? If you're under 21, it depends. If you're under 21 in the US, I'd say a year to a year and a half. If you're under 21 outside of the US, I would say 2 years, because you have to go through the embassy process. If you are 21 or over, 5 to 7 years. If you're married, 12 years. So yeah. Hi there, Natasha. Good morning now. Can one get a green card if spouse are living separately in different states? Yeah, it's possible, and that does happen. But we need to understand. We would need to understand. So you need to address that. Because I've seen that go south. So it's definitely a red flag. Living apart is in different states is a red flag, especially if they find that you are trying to hide that issue. And keep in mind, they can find it by running certain public records. They can find that you've been living in separate states. So you have to tackle that head on. Yeah, sometimes that happens if you have to work in different states, you have to go to school in different states. Maybe there are custody issues from previous children. We did have a client who that happened, and they issued a notice of intent to deny at that point, but we were able to show that it was necessary because of custody issues. One of the parents had to be there for their child. So it just depends on your circumstances, but don't hide it. Make sure you are tackling it head on, and give us a call, because doing it right from the beginning is going to be crucial. Thanks for the love on TikTok. I really appreciate it. So go ahead and give us a call. But keep in mind that, Damien, go ahead and give us a call. All right. Okay, let's see. I would love to stay here I would stay here for hours if you let me. But I know that if I do not get rest, I am going to be a wreck in the morning. I'm going to answer a few more questions on Instagram and a few more questions on TikTok, and then I'm going to head out. What's the number? It's 561-405-4889. You'll see it going across the screen on that ticker at the bottom of the screen on Instagram, YouTube, Facebook. Can citizen parent filing for daughter over 21 in the US talk to us? No, I would say that's a very risky situation. If they're over 21 and they've overstayed, that may be an issue, and you may be risking getting a notice to appear. Now, if they are here and all the conditions are right, their priority date is current, right? Which usually means you've already filed the petition. they're here visiting, they're still in status, then filing an adjustment of status is okay in that case. But if all those conditions are not at this, doesn't exist, it's going to be a problem. I'm undocumented. Can I travel to another state with my passport? The risk is high that you will run into problems. You may not, but the risk is high right now, just because they are. Keep in mind, people are being detained, you know, in areas that are not even close to the airport. So imagine where everybody is. You have CBP, you have TSA, you have police, you have all this law enforcement in the airport now. Um, your risk is going to be higher there. What's the cost for the consultation? $150. You can give us a call right now. We will answer. Is it true we don't have evidence for VAWA? Is it true we don't have to have evidence for VAWA? No, it's not true. The evidence, though, that you can have is your statement. Your statement may be enough. That is evidence, but you can't file it without any evidence. You have to file it with at least a statement, at least proof that you've lived together, that you are a person of good moral character, that your marriage was bona fide if it's a marriage based, and proof of relationship. So call us. We can determine what's appropriate for your case. Now, do you need the evidence that you think you need? A lot of people have the misconception that um, you need to have you need to have a police report, or you need to be divorced. You can't be with a person anymore. And that is not true. But evidence needs to be attached. It just depends, though, on your circumstances and what you have. And that's where we would need to talk to you to see, do you qualify? Is it customary for a person to get more than one biometrics appointment for VAWA? I've seen it before. I've seen that before. I don't know what your situation is, but I've seen that before. My husband is incarcerated. I don't know what to do. He begged me to stay and we got married there. I don't know what to do. He's being accused of SADV but not convicted, as I overstayed because of him. I have been financially supporting him, and it's hectic. Some say I should file VAWA because it is financial abuse. Financial abuse does count. Give us a call. What you're going through, we help clients to get through those situations, to be able to get their papers. So let's talk. I'm so sorry you're going through this, but this could be the start to get free from that and be able to move forward with your life and gain control of your situation. So give us a call. You can even call us right now, and we'll be able to book some time to talk. Okay. So having a statement is evidence. What are the options available for F1 students? Um, no, it depends on your particular situation. If you're an F1 student, we'd have to talk to you to see what are your goals, what's your situation. Do you have a current F1? Have you overstayed? Is it expired? So that's what we'd have to determine. How can you help me with a religious visa? So the R visa, it would have to be a religious institution that sponsors you. So that would be the first step to be able to get that. Can one get a green card if spouse are living? Okay, so answer that. How likely to get BFD EAD for T visa application? So it's discretionary. I would say if you have a clean record, you've properly filed a T visa application, so everything is there. The BFD is a likelihood in that case. I apply my mom green card. She got it. How long can I wait to marry my kid's dad his asylum? So you don't have to wait. You can apply for your mom and you can apply for your spouse at the same time. If you're a U.S., which you're a U.S. citizen, so I would say ASAP. Now it depends on how your spouse entered the U.S. So give us a call. We'd love to talk to you about whether what he qualifies for, but we need to understand how did he enter, did he enter with a visa? What's the situation with the asylum and so forth? I would like to know if you assist in filing for K1 visa. My fiance is a US citizen. Absolutely. Give us a call and we can talk about the best option going forward. Hi, I am from Maryland. That's one of Baltimore is one of my favorite spots. Um, So hi there in Maryland. I applied my mom green card. She got okay, so I answered that. Um, Hi there. I am good at game. Thank you. Hi there, Donovan. It's nice to see you. So, can I apply for asylum after 4 years? Can you please help me? I have been married, but her financial is slow. Call us and we will look at what the circumstances are. Why didn't you apply within 1 year? Sometimes there are ways that we can apply for asylum even after the year deadline, to the 1 year after your entry. So talk to us, and then we'd love to know what the situation is with your spouse as well. So the first step that you have to take is to talk to us first. Do those with a pending U visa case of January 2022 have to wait 10 or yes, you have to wait the full length. But here's the deal, you can get deferred action. Deferred action, once you filed a properly, once you've submitted a properly filed U visa with a certification, you've passed a background check, then you may get what's called deferred action that gives you protection and you can continue to renew your U visa, your basically deferred action work permit until you get approved for the U visa. Can visitors change to F1? Yes, that's a possibility, but you have to be very careful with it. Timing has to be right. You have to have a plan in place. If it's very long, possibly defer your admission to the university if it goes, because usually changing your status while here can take over a year. So it's not anything you should be doing last minute. Good night. If I was filed for when I was young and my father didn't complete the document, what's my options? So did your father file for you on or before April 30th, 2001? There may be an option there under section 245I, but no, but if you qualify there, then the next thing would be who qualifies you? An employer qualifies you for the adjustment of status. A parent, a spouse would also have to look at that. How soon can I get my PR, my permanent resident, once my EB1 is approved? So EB1 is extraordinary ability, And the first thing is, was it just the petition that was approved? Or did you apply for adjustment of status at the same time? If you applied for adjustment of status at the same time and you're here in the US and you complied with all the rules, like you applied before your status expired, then once I would say the petition is approved, then they're just going to look at admissibility issues. It could be another 6 months to a year, and then they will issue the green card after the adjustment of status is approved. If you're outside of the US, then they're going to send you, they're going to send it to the NVC, and then you're going to have to provide required documents or process it. If that's approved, then you go to the embassy for the interview. All right, that's going to be it for me today. Thanks everybody for your time. I really appreciate it. These were all great questions, and I will be back later on today. So what I say is like, subscribe, hit the notification bell. That is how people see this, and also how you'll get notification when I hop on, so that you can come and get updates and get your questions answered. If I didn't get to your questions, there's always later on. All right. Have a good night, everybody. And just remember, with everything going on, we have to look at solutions. And I talked a lot about solutions tonight. So be proactive and act on solutions. Even though things are difficult, things are difficult right now, especially, I know I know that a lot of us are tired because of the kinds of issues that we constantly have to face. But we have to move forward. We have to take action on solutions, right? We can't be sitting ducks. So get in touch with us. Let's talk about potential solutions. All right. Have a good night. Bye-bye.